To be a trial attorney, you have to be pretty good at psychology because your job is to convince a bunch of people that you have never met to side with your client. And as much as we'd like to think so, we don't make our decisions based purely on facts. Everyone has certain biases that are hardwired into their brain. And by bias, I don't mean something like racial bias. Instead, what I mean is a set of intuitions that you have that you accept as true, usually without thinking about them. Somehow humanity as a whole has developed to have these biases. So a good example is a confirmation bias. For personal injury attorneys, a big part of confirmation bias is that jurors believe personal injury cases shouldn't happen or shouldn't happen as often as they do. And what is a confirmation bias? A confirmation bias is anytime you believe something, it's going to be easier for you to accept and believe something you read or hear that matches the belief you already have. When you hear something that goes against your belief, it's very easy to say, yeah, I'm not sure that's true, and then not look it up any farther. So you push away the stuff that disagrees with your current view, and you bring in the things that agree with your current view. For personal injury attorneys, we deal with the problem that jurors believe there shouldn't be personal injury lawsuits, or at least that there's too many personal injury lawsuits. And we could debate that with facts, but that's not going to convince our jurors. We have to play to the confirmation bias and say, we understand there may be too many personal injury lawsuits, but this is the one that's the exception to the rule. This is the one you should accept because it's different. And that is part of the art of persuasion as opposed to just telling someone they're wrong. So what's another bias that we deal with? Well, one is the anchoring bias. Anchoring means that when you hear a number, you are more likely to decide something else has a value or a count that is similar to the number you just heard. So an example that they'll do in schools sometimes to prove this is they'll put the jelly bean jar in. You have to guess how many jelly beans there are. And then they'll give the kids some random number that has nothing to do with it. And sure enough, those kids constantly guess numbers that are closer to the one they just heard, regardless of how many jelly beans are actually in the jar or how big it looks. For our jurors, this happens frequently when they hear numbers during the trial that don't necessarily affect or relate to other numbers. What's an example of that? Well, first, medical bills. There are laws in some states, including Ohio, where you can only talk about a certain amount of the medical bills, not necessarily the total amount billed. And this can be an extreme change sometimes. You can have medical bills that are $1 million, but Medicaid gets most of that written off, and so it's only $200,000. And when you start talking about different types of damages that don't have an easy number fixed to them, the jury makes a very different decision about those damages when they only hear 200,000 as opposed to if they'd heard 1 million. So what's an example of that? Pain and suffering is a damage that there's no yardstick for. You can't say that if a certain thing happens, the pain and suffering is always this certain amount, because it'll be different for different people. It's both your physical pain and your mental, emotional suffering that kind of affect on your life. So pain and suffering is kind of rationally related to your medical bills in the sense of they both go back to how physically hurt you are. But if I tell my jury that the medical bills are $1 million, or if I tell them that the medical bills are $200,000, they're going to come up with a very different pain and suffering number. And so we have to deal with that bias, and we have to anchor them to a number that may be closer to the $1 million billed as opposed to the $200,000 that we're allowed to tell them about in court. And I don't want to give all our tips and tricks away for that, but we've developed a lot of techniques over the years to make sure that the jury anchors to a higher number rather than a lower number which is going to improve the damages they assess for our clients.